I'm here with Premier Las Vegas criminal defense lawyer Michael Becker. And Michael, people call us all the time and they ask us with regard to battery domestic violence. Normally it's a misdemeanor, but sometimes it can be a felony, right? Well, when is it a felony?
There are several circumstances which can result in a battery domestic violence situation turning into a felony. First, if you have a third time battery domestic violence, that would be a felony.
So if you have two prior domestic violence convictions, then third is automatically a felony.
That's correct. Also, if there's a battery with strangulation, that can be charged as a felony. If there's a battery with substantial bodily harm, that can be treated as a felony. And if there's a battery with use of a deadly weapon in a domestic situation, that would also be treated as a felony.
Now, this substantial bodily harm. So you're saying even if the person has no prior record, if they cause injury to the alleged victim in this case, then it can be charged as a felony. What kind of injuries are we talking about? Because usually the police come, maybe there's some redness or some scratches. I mean, is it superficial injury like that, or is it like something real serious?
Well, I would say if it's superficial injury, typically we expect to see those cases filed as misdemeanor battery domestic violence. But the more serious the injury is, the greater possibility that it could be filed as a felony charge. And ultimately, that's up to the discretion of the prosecutor's office when they make a filing decision as to whether or not to file it as a misdemeanor or a felony.
And even if it is filed as a felony, then as a criminal defense lawyer, many times you're able to sometimes get it reduced to a misdemeanor or even get the case dismissed.
That's right. A lot of factors come into play. And it's not uncommon to see a domestic violence case filed initially as a felony, but negotiated down to a standard misdemeanor battery domestic violence. Again, a lot's going to depend on the circumstances. Sometimes it could have to do with the willingness of the alleged victim to step forward. Sometimes it could have to do with the merits of the allegations and the fact that there's a second story that the defendant might have that totally contradicts the accuser.
The client may have acted in self-defense, or the injury may have happened as a result of an accident. And oftentimes that occurs, and it looks to the police when they get there like there was domestic violence.
That's correct. And I would say the most common scenario that we see is that the initial aggressor ends up getting the worst of it. So maybe the person that was hurt was struck with a blow that was thrown in self-defense, and the police come and they typically
jump to conclusions.
They often jump to conclusions, and they often tend to arrest
the man.
Well, often the man, or alternatively the one that doesn't have the worst injury.
But that doesn't necessarily mean that one is a victim and the other is a perpetrator.
That's correct. So you really have to, in domestic violence cases, you really have to sift through all of the evidence, speak to all of the witnesses to get the full story. And, if the DA realizes that they may have gotten it wrong, you present the evidence to them, and often you can negotiate a reasonable resolution.
And if the DA doesn't agree, then often you present your case to a judge or a jury and go for a not guilty verdict.
That's correct. I think we see trials in these types of cases at a higher percentage than you would in other areas of criminal defense law. I'm attorney Michael Becker with the Las Vegas Defense Group. If you've been charged with battery domestic violence, we know there are two sides of the story. Call us at 702-DEFENSE. Let's hear your side of the story, and let's see what we can do to help you get your charges reduced or dismissed.